welcome to CareSmarts 360 on air, home care podcast. I'm Dennis Gill, senior sales consultant at CareSmarts. So today, we are diving deep into the world of legal advice for home care agencies. And who better to guide us than the man himself, Bob King, the legal guru behind Legally Nanny.
Well,
Bob
thank you
has
very much for that kind introduction. I appreciate those words.
no, yeah, that's just the kind words, and we also always wanted to introduce you like this. So, Bob has practiced law in Orange County before it was school. But wait, there's more. He's the founder of Legally Nanny, which is basically the legal equivalent of a nanny's superhero cape. So, whether you're dealing with the tricky termination, navigating wage and hour laws, or just want to make sure your home care handbook is up to snuff, Bob's got your back. So, tune in to hear his expert advice and get ready to level up your legal knowledge. So, welcome to the podcast, Bob.
Well, thank you very much. It's great to be here. I appreciate that kind introduction. The irony of Legally Nanny is that we started it, 22 years ago because we were hiring a
Okay.
nanny and wanted to do everything legally. And
Uh-huh.
now almost all of our work is home care. And so people say we should rebrand and call ourselves Legally Granny, to stay up with the times. So,
Got that, got that. I completely understand the
but no,
point.
we represent home care agencies, nanny agencies, and family employers. So basically, anyone who works in the home, we
Mhm.
we represent the employer in those instances.
Perfect. Got that, got that. Got your point. All right, so let's straight away get into the questions that we have dived in. So, firstly, first thing first, what are the questions you can and can't ask the prospective caregivers during the interview process?
Right. So that's a great question. And what I want to tell people is you should just ask the questions that you feel will give you the best answer for how they're going to be a caregiver. So, frequently, the best questions are narrative questions. Why do you want to be a caregiver? What experience do you have in caregiving? Those sort of broad, open ended questions are excellent. Where you get into trouble is if you ask any questions that involve any legally protected characteristics or practices. So that's all of the basic things that would come to mind: race, age, religion. But here's an important one: you can staff based on gender. And gender,
Mhm.
normally, you can't make any sort of hiring decisions if you were working in an office or anything like that. You couldn't. In home care, you can, and that's an important distinction, as long as the case involves bathing, dressing, or personal care. And
Mhm.
I've had cases where male caregivers sue home care agencies because they claim they're being discriminated against based on gender. So it is something that occurs. And I'm warning home care agencies, the critical thing is, if you're going to staff based on gender, make sure there's a notation that there's bathing, dressing, or personal care involved so that you don't run into those problems. But
Yeah.
again, and also here's the thing, Dennis. And by the way, I like to talk, so this could go a while. So I'll warn you that already. But it's truly all in how you say it. So, for
Uh-huh.
example, I believe that most people are good people. They just don't know how to word things correctly. So they may say, for example, we want a Mexican caregiver, and you say, well,
Mhm.
why do you want a Mexican caregiver? And they'll say, well, mom only speaks Spanish. Okay, that's totally cool. That's
Yeah.
just not phrased correctly. So we'll say Spanish speaker required. Or like the funniest one I have is, oh, well, we want a Jewish caregiver. Why? Because we keep a kosher house. Okay, knowledge of kosher house required. Who do you think you're going to get? Right. So,
Yeah, got
that's
that.
the key thing.
I get
And
you.
in terms of if you phrase the question based on legitimate job based requirements, you're totally fine. That's legal. It's just you cannot try and ferret out any marital status is another issue. You can't ask, do you have your own children or anything like that. You can't go into medical histories. This is not
Mhm.
a dating site, so you're not going to ask about height and weight and eye color and
Yeah.
any of that sort of stuff, right?
Right, right.
Right? You're going to ask the questions you need to find the best caregiver who has the experience and frankly the passion for your business. There you go.
Rightly said. Rightly said. I know. So the phrasing can be a very important aspect. So listeners and the home care agency owners, whoever are listening to our podcast, please make a note of that.
Exactly right.
Okay, so what are the best practices to document caregiver performance issues according to you?
Okay. So the critical thing, there's that old phrase, diamonds are a girl's best friend.
Hmm.
Documents are a lawyer's best friend.
Yeah.
Okay. And it's absolutely critical. And this happens, I without exaggeration, on a weekly basis. I will get a
Uh-huh.
call from a home care agency owner that'll say, Susie's been a terrible caregiver. She's been late, she's unprofessional, blah, 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 blah. And today she told us that we want to fire her, and today she told us she's pregnant. What do we do? Okay.
Oh.
And then you say, is there any documentation of any of this in the file? Well, no. Okay.
Hmm.
Well, that's a problem because you're going to say, she's going to tell you, she tells you she's pregnant, and literally the next day you're going to fire her. What do
Yeah.
you think that looks like? Even if you have good reasons, but you don't have good reasons if it's not documented. So what I say to home care agency owners is, have those hard conversations. I understand they're difficult because you don't want to offend people, or they're just challenging to say, "Hey, Dennis, you could be doing this better," right? But again, it doesn't have to be phrased like, "Dennis, you're doing this wrong." It can be
Yeah.
like, "Dennis, this is how you do things better." Okay. And then make a note of it in the file. Even those verbal counseling sessions should have some sort of note in the person's personnel file. And what I say is, have a performance improvement plan in place. A PIP is terrific because it specifies what the problems are, it outlines the deliverables, and it gives a deadline. And if they don't
Hmm.
meet those deliverables by that deadline, you can take disciplinary action up to and including termination. And that's what you want to do. So you want to have documentation in writing for even verbal counseling sessions, and then it's verbal, a first written warning, a final written warning, and then they're fired. I like to see that documentation. You don't have to go through that whole process, okay?
Okay.
Obviously, if someone abuses the client or steals from a client, you can fire them right away, okay?
Right
And
away.
the
Yeah.
other thing I would tell people is, and this happens, again, this happened just in the case recently. If you have a good reason for firing someone, always note it on the termination document. Always, always, always. Because otherwise, if you say, we're terminating your at-will employment, well, that leaves open a lot of speculation and a lot of questions, doesn't it? Why did you do
Yeah.
it? Was it discrimination? Was it retaliation? Any of these sorts of reasons. If you say instead, we're terminating your employment because you were late 3 times in the last 2 weeks, or because you acted unprofessionally by yelling at a coworker, or whatever it may be, then you've got your reason in black and white right there to explain and to rebut any sort of cause of action for discrimination, retaliation, etc. So document everything from verbal counseling sessions, do performance improvement plans, verbal first, final warnings, and then always specify in the termination notice, always, 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 why you're terminating somebody.
Right. Is that so, listeners? Please do make a point of that and do document everything.
Exactly. I mean, we hope you never have to do it. But the point is, if you document the good, you should
Yep.
document the bad.
Document the
Otherwise,
bad
you've
too.
got a file. And plaintiffs lawyers love documents as much as defense lawyers because they'll go through it and they'll say, well, gee, here's the review that was just a couple months ago and there's nothing negative there. Or
Hmm.
here's a commendation from a client, right? They'll always get that. Or here's a Yelp review where the caregiver was mentioned. She must have been a star, and
Yeah.
yet you fired her, right? So that they can pile up a stack of really good documents and you'll have nothing because you didn't want to butt heads, or you didn't want to be confrontational or hurt somebody's feelings, and then you've got a real problem.
Got the point. Got the point. Okay, maybe link to that, the next question that how can agencies stay compliant with the federal, state, and local labor and employment laws, especially in terms of caregiver wages, hours, and benefits?
Right. It's constantly changing and it's
Uh,
incredibly difficult. And so what I would say to people is, first and foremost, I'm not here to plug our firm, okay? But find a lawyer that you're comfortable with who knows the
mm,
home care space wherever you are, and stick with that person because that person will provide you with updates. Just like you don't want to, if you have a headache, the last thing you want to do is Google medical symptoms for a headache because
yeah,
you'll think you have dengue fever afterwards, right? It's the
yeah,
same thing. Please don't Google legal issues. Invariably, AI will be wrong or not include
yeah.
it. Like a good example is, um, in the state of California, you're
Hmm.
required to pay overtime to caregivers who are personal
Hmm.
attendants working in a private home. And
Okay.
see, there's all these little caveats. I sound like a lawyer just explaining this example, but it's true. If they spend 80% of their time supervising, feeding, and dressing, and they're
Hmm.
working in a private home, they're considered personal attendants. If they meet that test, they're entitled to overtime after 9 hours in a day and after 45 hours in a week under California law. So you Google that, AI will spit out 9 and 45. That's
Yeah.
wrong. Why? Because under federal law, caregivers are entitled to overtime after 40 hours in a week. So the
Okay.
correct metric is 9 and 40, but you wouldn't get that if you Googled it because
Yeah.
Google's wrong. So what we do is I don't have time to write newsletters. My clients generally don't have time to read them. Instead,
Hmm.
we put it on our socials, Facebook, LinkedIn, and X. On a regular basis, you will get updates from us about all the laws that impact your home care agency on a federal, state, and local level. I'll also say, as a shout out to our California listeners, if you comply with California law, you can almost always ignore federal law because California law is so strict and so employee friendly. Like, for example, there's a lot of kerfuffle about non compete agreements.
Hmm.
Non-compete agreements have been illegal in California for as long as I can remember, and maybe on a federal level they may be becoming impermissible. But in California, if that's where you are, don't worry about those federal developments so much because California law already is far more protective. It's not always true, as we said on the overtime. In that instance, federal law is more generous. But generally speaking, don't be so concerned about federal law, or you can stay up to date on it, obviously that's important. However, make sure that you're also aware of of state and even local laws. Like here in California, there's probably 20 plus jurisdictions that have local minimum wages. There's half a dozen that have local sick leave laws. Okay,
Okay.
and so you have to stay up to date on all that. How do you do it? Find a lawyer who can keep you up to date. Follow us on our socials. Our socials will always keep you up to date. And the
Yeah.
last thing I would tell you is go to conferences. Okay, the Home Care Association of America, where I will be in September, and where I'm sorry, in October, and where you
Okay.
will be as well, is a great resource to get all of your legal knowledge. And then there are state associations as well that provide programs. Staying involved is not just some sort of civic duty rah rah. Staying involved actually keeps you up to date
Hmm.
by going to those meetings, going to those conferences, and getting the legal knowledge you need. And that's what you have to do. Otherwise, the law changes so quickly. Like, for example, in January of this year, all I did was update handbooks. That's all
Okay.
I did. I mean, it was a massive trove of work. And it's because the law changed so drastically, it required a slew of updates. And you see
Hmm.
it now. Like there was a required notice on Valentine's Day of all days to go out in California about non-compete agreements. There's a new healthcare minimum wage that just got enacted in California and was effective yesterday. So it's
Yeah.
not just the beginning of the year or certain times, it's all throughout the year. Life changes. So stay
Yeah.
up to date with a good lawyer who you like. Follow us on socials, go to conferences. That's the way to do
So, listeners, we have the right person over here. So, any help required,
it.
you can contact Bob.
And we
Okay.
give it away for free. And I'm not kidding. Follow us on our
That's the best
socials.
thing.
We
Yeah.
like people ask us questions that are billable, and that's great. I'll bill you for it. But instead, if you want to just get the answer for free, please go to our socials. And by the way, when we do that, we also
Mhm.
post a link to the law. Okay. So
Uh-huh.
if there's a question that's not answered necessarily, of course you can call us. We're always happy to talk. However, I will give you the link directly to the source so you can look at it yourself. And that's important because sometimes summaries or snippets aren't accurate or don't include all the situations. I'm going to
Yeah.
give you the source material with a link that you can go to for free.
Perfect. Perfect. Okay. Another thing that what are the legal implications and best practices for terminating caregiver employment, including documentation and communication requirements? I think you answered it half earlier, so
Right.
maybe
And I'm
some more
right.
thing.
But I want to go through that because here's the thing. It's not
Yeah.
just tell them why if you have a good reason. Okay.
Hmm.
If you don't have a good reason, then it's sort of like dating. You can say you're not a good fit, it's not you, it's me, whatever. I don't really care if it's just a personality conflict or whatever. I would actually say it's personality conflict. But
Hmm.
generally speaking, if you've got a reason, give it to them. If you don't, just you want to just carefully terminate their employment and just say it. We're terminating your at will employment. But that's half of it. The other half of it is essential to comply with state and local laws regarding termination. For example, here in California, the
Yeah.
way many agencies get in trouble is they say on a Tuesday, you're fired. And by the way, your final paycheck will hit with your normal direct deposit on Friday.
Hmm.
That's illegal. Okay. Under
Okay.
California law, you have to pay people all wages owed at the time of termination. And if you don't, you can get hit with up to 30 days penalties. And so
Oh.
clients will be like, oh no, I'm going to get hit with a
Oh,
month's worth of wages. And it's like,
yeah.
no, actually, it's worse because it's 30 days of
30
wages,
days.
right? Which is
Yeah.
even worse because that's more than a month, right?
More than a month. Yeah.
So make sure you comply with your state requirements for paying people. In California, as I said, it's all wages owed at the time of termination, which is why oftentimes people will be put on unpaid administrative leave.
Hmm.
The employer is not investigating things. They are waiting for their payroll department to cut the check and finalize things.
Uh-huh.
And in addition to the termination write-up and explaining why, and the final paycheck, there's one more critical component to termination. Usually there is documentation that has to be provided to an employee. So here in California, there's 3 documents. There's a
Hmm.
notice to employee. It's called notice to employee is to change in relationship. And many states have this form. And it's designed for unemployment. And the form simply has the employee's name and social security number on it. And it states the day of termination and the reason for termination. And then
Okay.
the employer's name at the bottom. Why? Because the employee, when he or she files for unemployment, is going to submit that form. Okay. So it's critically important that you give them that notice to employees to change in relationship. That's the name of the form in California, but it's a similar form in most states. There's also a booklet about programs for the unemployed that you're required by law to give them. And then there's a notice about health insurance. That's another
Okay.
really critical thing. Okay, so even if you don't provide health insurance in California, you're required to provide a notice. And certainly if you do, you're required to provide those COBRA notices. And so here's the problem. Many employers think they're offloading liability because they're firing someone. But if you fail to take these critical steps, literally each step that you fail to do, you incur more liability. So
Okay.
remember, when you terminate somebody, the 3 things are the termination notice, the paycheck, and all the other required state and local documents that you have to give them when you terminate them. It should be an easy packet for your HR department to deliver, but it's essential that the timeliness of it occur
Hmm.
at the instant of termination. And by the way, these don't even have to be paper copies. You can email these documents. That's completely fine.
Uh-huh.
Another thing that people often overlook with termination is I strongly recommend that you sit down with the person. Usually there should be 2 of you on your side of the table because it's important to have a witness, okay?
Yeah.
And when you have this talk, you explain to them why you terminate them. It is again like dating. Does somebody want to be broken up with over a text? I always tell people treat someone with respect, okay? Because a happy employee, or at least an employee who is heard, is less likely to sue. So in that final termination meeting, you ask them, is there anything you want to tell us? And so often they just want to be heard. They want to get something off their chest and they feel relieved. And then you take it constructively. You don't dismiss it, even if you disagree with it. You thank them for raising it. And you say, I'll look into that, or we'll make that change, or whatever. We will investigate or evaluate that suggestion. That's a good idea. And I appreciate you bringing it forward. Also, super important, make a list of all of your property that the employee has and then collect it at the time of that termination meeting. That's another reason why you want to do this in person as opposed to phone, email, or text. You want to get your stuff back. Okay.
Yeah.
And your stuff might be a t-shirt like you're wearing that has your company logo in it that you don't want an employee who's no longer working giving it back to you, right?
Definitely.
So
Yeah.
when you schedule the termination meeting, you say, and Dennis, here's a list of our company property that we expect to be returned to us at this meeting. It's
Yeah.
very helpful. And if it's an office employee, you want to get your laptop back. And the last thing is, and people forget about this because they're so rushed, but it's all these important details. You want to turn off their email and cut off any access, passcodes, all of that sort of stuff. Cut it off because employees can be malicious. They'll send an
Yeah.
email from their ABC
Official.
home care
Yeah.
agency, it was saying the most outrageous things because they have access to it. Or they'll stick a USB drive into something and download your confidential information. So really, really important at the instant you fire them to cut off all of their electronic access and monitor what they're doing. Have your IT people monitor what they're doing. So firing somebody isn't just you're fired. It's following all these procedures to make sure that it's done in a dignified way, to respect the employee, but also to protect your agency.
Right, right, right. Obviously, this will be a great help to all our listeners, all the agency owners who will be keeping a track of this from now on.
Well, it seems obvious, but here's the thing. In the heat of the moment, you forget
Yep.
about these things.
Yeah.
You
The
forget
basic
about,
things, just the basic things
right,
that are there.
right. You
Yeah.
forget, oh my gosh, we didn't change the passcode, or
Yeah.
whatever it is, or she still has an office key, or she's wearing my t-shirt in a video bashing my company, or whatever it may be. You want to get
Right.
all that, or I've seen this too. I've seen caregivers go back into facilities because they still
Uh-huh.
have their name tag and try and recruit clients privately. And the only way
Oh,
they get access into that facility, because the facility may not even know you fired the caregiver, is
yeah.
because they've still got their ABC home. And by the way, I'm not referencing, if there is an ABC home care agency out there, I'm not referencing you in
Yeah.
particular. I will call it XYZ home care agency,
Yeah.
but they still have their badge and
Yeah.
they can still access the facility and recruit your clients. So it's really, really important for you to have a level head and to make a list and to get it all back.
Perfect, perfect. Thank you for that, Bob. And just one last thing from my side, that how can we mitigate the risk of legal claims or disputes arising from caregiver employment, basically such as wrongful termination or discrimination lawsuits?
Sure. So, first and foremost, like I said, you want to treat them with respect and dignity on the way out the door. Okay.
Hmm.
You want to let them be heard. That's the
Yeah.
most important part. And then, secondly, while they're employed with you, okay, even before that, happy employees aren't litigious employees. Okay. Happy employees generally don't sue. Treat your employees well. I know it sounds so simplistic, but it's the God's honest truth. It's the agency that has the annual holiday party, or that recognizes a caregiver of the month, or that where the owner just goes out of his way to send a quick text to a caregiver to say, great job with Mrs. Jones today. Or I noticed that you've been on time 50 straight times. Thank you. We and our clients appreciate that. It takes the owner 15 seconds to do that. You can
Yeah.
even have it the same script and you just have a software program that alerts you when somebody hits these milestones 50, 100 times, whatever, show up on time. And you send them a quick text. It means so very much to them. Okay. The next thing is, remember, if you're going to give your employee anything more monetarily than they're entitled to, that's great, okay? I'm not saying you should always provide severance. Most of the time, it's not necessary. You don't have to do it. Legally, you're fine if you don't do it. But if you're going to pay somebody extra to say, and again, I keep using you, Dennis. I'm not firing you in any way, but we're going to keep
No, no,
using
it's
you as an
okay.
example,
It's okay.
okay?
No, it's
So,
okay.
so Dennis, you've been a great employee. We appreciate everything you've done for us. We want to give you an extra $500 in your last paycheck. And you say, thanks so much. And I would say to you, I would say to that agency owner, hey, you might as well take that $500 and throw it out the window because you just got nothing for it. So
Hmm.
if you're going to pay anything extra, please contact your attorney and get a severance agreement. A severance agreement is very simple. It's just a waiver of claims, but it
Okay.
also has important provisions like confidentiality and non-disparagement, meaning you can't share our confidential information and you can't say bad things about us. Okay.
Yeah.
So, and then they'll say, oh, but I don't want to complicate it. And I always explain, blame the lawyer. Always blame the lawyer. Okay. So I would say to you, Dennis, we really appreciate it. I wanted to give you this check for $500. I just wanted to give it to you straight away. But my fancy pants lawyer jumped up and down and said, I can't give you this until you sign this document. And this document, Dennis, it just says you're not going to sue me. I know you're not going to sue me. I'm not worried about it. You're a good guy. But you got to sign it. Otherwise, my lawyer says I can't release this check to you. I'm really sorry. I wanted to fire the lawyer for years. He's really expensive and blah, 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 whatever. But
All that, yeah.
whatever. Blame the lawyer,
Hmm.
but get the signature because you get the signature and you're generally bulletproof. That's your best way to do it. Also, be careful If you have a lot of employees and you're doing a mass layoff, there's something called the WARN Act, WARN, that is on federal law, but there's also state versions of that too. If you're doing a mass layoff, you have to give notice, and it's a prescribed notice under federal law. So if you're closing your business and you have, say, 100 employees or more, the federal WARN Act will be triggered. So please be aware of that. Okay. That's mass layoff situations. But what I'm talking about here, generally speaking, is treat your employees right while you have them. Always be respectful out the door. And then the last thing is, if you're worried about a claim, do a severance agreement. And that's the beauty of the severance agreement. You're already pushing other papers across the table. I already have to give you 3 different notices. So one more document is not going to be a big deal, right? And then I give you that and I say, and always, always have the severance check ready right there. It's like putting cheese in front of a mouse. You slide the check across the table and say, Dennis, you can take this right here, right now, if you sign this document. And it's free money to you. Often caregivers live paycheck to paycheck anyway.
Yeah.
They weren't going to sue you. They'll sign that severance agreement. They'll take that check because you've given them the incentive to do it right then and there. So that's my advice for how you terminate an employee.
Got that. Got that. So thank you, really, Bob, for sharing your expertise today. And
Sure, it's
it
my
would have
pleasure.
been definitely helpful for all our listeners, agency owners, anywhere you're from. And to our lovely audience, thank you for tuning in. Until next time, I'm Dennis Gill, signing off. Have a great one. Thank you.